Hunter's lawyers claim he's already got full immunity. They say that the deal was entered, grants him that immunity because it was a private agreement between the government and Hunter. We know the plea deal came to a catastrophic collapse, and the plea deal was ultimately rejected. But the plea deal requires the judge to approve it and accept it and hold everybody to the terms. The diversion agreement, which was the separate document that was very convoluted in this very strange deal for which the judge said there was absolutely no precedent, was not something that implicates the judge. And so Hunter's lawyers are now saying that deal is as good as executed. Hunter's already been abiding by the terms and he's got full immunity. So what is David Weiss, the special counsel, doing? If he's investigating Hunter for those same crimes for which Hunter is immune, we're in this circle of no ability to prosecute because Hunter is immune. So what is going on here? Now, there's been a lot of activity. From the court docket, we see several different filings. Cases, United States versus Biden out of Delaware. Several things happened. The government, the United States, which is Hunter's daddy's Department of Justice, they filed a motion to vacate the court's briefing order. The briefing order is the judge ordering the parties to give me an update. I want this issue briefed and I want this issue briefed. We know the plea deal broke apart. The judge had a bunch of questions. Why? Let me know, write a memo and get it to me when it's due. The government filed a motion to vacate that. They said, hey, we don't need that briefing order anymore. And they also filed a motion to dismiss the text charge because they're going to file it in another location. Then the judge said, wait a minute, you're going to be filing, vacating, and dismissing all of this stuff? Okay, so how about this? Judge Norica said, all right, defense, Hunter Biden and your team, you need to respond to this by noon on Monday. And guess what? They did. In this motion to vacate, they are basically telling the judge to get out. I want to use a swear word, to F off. Hunter's lawyers are saying, get the heck out of here, judge. It's condescending. And the judge has responded and said, okay, then, if you're telling me that I have no involvement in this and that immunity's already been granted, then I need the government to respond. It is hereby ordered from the judge that no later than noon on Tuesday, August 15th, the government shall file a reply to Hunter's claims of immunity, signed by the judge. And so the government is going to have to explain themselves as well. But let's go through the different filings. Out of the United States District Court for the District of Delaware, 3 pages. This comes from the government, Hunter's daddy's Department of Justice. Cases USA versus Hunter. This is the United States motion to vacate the briefing order. They say, all right, judge, hey, the United States is submitting this. We want to vacate our briefing order because it's moot. When we were at the hearing back in July, the court judge, I know you ordered us to do the following. Here's what you said. The judge said this, said, okay, so this is what I'm going to do. All right, these agreements are not straightforward and they contain some atypical provisions. Judge says, I'm not criticizing you for coming up with those. I think you've worked hard to come up with a creative way to deal with those, but I'm not in a position where I can decide to accept or reject it, so I need to defer it. First, I don't know which rule this falls under, and I'm not convinced that it is actually a plea under subsection B, which you all suggest is me rubber stamping the plea if it's a knowing plea. But even if it were, judge says, I have testimony under oath, both that Hunter is concerned about the immunity, and he doesn't need that in terms of the plea agreement. So she says, I need to think about that. Additionally, I need some understanding, government and defense, under B, subsection B, and that my concern about the form over substance of the agreement, not to prosecute, is not valid or why I should do this. She says, so I would like some briefing, additional briefing on why subsection B is appropriate, and if I were to determine that this is actually a plea under subsection A, it would be helpful to me to have your views on that. What it would take to make this plea acceptable, because I'm not saying that it's not. Nobody seems to have really given me what I would need to determine if I read this thing as a whole. So I need that. And then I would like, as you offered, Mr. Clark, Hunter's lawyers, you guys go back and work on whether or not you can take out paragraph 14 of the draft diversion agreement and come up with something else that's acceptable. And while you do that, you might, though I'm not trying to tell you how to negotiate your diversion agreement, you might fix that one paragraph that you have orally modified today, paragraph 15, which is the immunity section in diversion. The judge is ordering all this. I would like to understand why that provision, section 15, if you want me to go forward, is appropriate, and why I'm not doing something that gets me outside of my lane in terms of branches of government if I were to do what's being requested. So they're saying, okay, judge, you said all that, right? Well, the court's briefing, you wanted all of this. It's premised on the ideas that the parties want to intend and continue a guilty plea. Like, you want us to brief that, like, in case we take a guilty plea. Like you say, is it sub A, sub B, whatever. But they say, but that's not the case anymore. There aren't going to be any negotiations. The parties are at an impasse, and we are not in agreement on either a plea agreement, listen, or a diversion agreement. We are not in agreement, this is from the government, on a plea agreement or a diversion agreement. Therefore, the government believes that the court's order should be vacated. We're not taking a plea, doesn't matter if it's A or B, whatever. So the United States government requested Hunter's position on August 9th and asked for it by the 11th. They said, can we have more time? We said no. So at the time of this filing, they have not provided their position. As a result, the government, by Leo Weiss, this is the same guy who tried to cram this goes through, like all of our mouths, in court saying, no, I have no precedent. No, I've never done this before. Yes, I want to do it. Yes, I know what it means. It grants him total immunity from everything. I don't care. As a result, the government respectfully requests that the court vacate its briefing order since there is no longer a plea deal or a diversion agreement for the court to consider. But notice on this, he's saying we are not in agreement on a diversion. We'll see what Hunter responded because the judge ordered a response. The judge said, you better get back to us on this one. And they did. They filed their response. And here's what it says. Hunter Biden's defense team, 3 pages. This is Hunter's response to the government's request to vacate the briefing order. They say, hey, judge, this is Hunter's lawyer speaking. They say, while the attorneys for Hunter are still prepared to respond to the questions that you posed, that you ordered us to brief, they say, in light of the U.S. decision on Friday to renege on the previously agreed upon plea agreement, we agree that those issues are moot at this point. Nevertheless, we wish to inform the court of the following. So we're happy to answer your questions, Judge, but they are moot. In May 2023, Hunty, through his lawyer, accepted the prosecutor's invitation to engage in settlement and plea discussions that Hunter and his team of lawyers understood would fully resolve the sprawling 5-year investigation. So he's saying we came in good faith. Second, as is customary in negotiated resolutions, Hunter's lawyer is saying prosecutors and not Hunter or his lawyers, they proposed and largely dictated the form and content of the plea and diversion agreements. I just want to pause on that. The government prosecutors proposed, this is according to Hunter's defense. He says, we're just sitting here. They made the offer. They came to us. Hunter Biden is being prosecuted by the Department of Justice. Who runs that? Merrick Garland. Who is in charge of Merrick Garland? Joe Biden. So the DOJ says, we have this, we'd like to immunize you. We'd like to make you plead guilty to some misdemeanor tax stuff. And then you can have a diversion on the guns. And then everything's going to go away. You'll have no felonies on your record. Everything's going to be fine. They offered it to him. They're like, sure, we'll take it. That's a great deal. We'd also like some fries with that too. Can you please bring those too? And they're like, yeah, sure. How many orders? So Hunter's team says this is true with respect to the form in which the documents were presented, how we structured this with the diversion and the other docs as 2 separate and independent agreements, as well as the express language of paragraph 15, which is the so-called immunity provision. That's the government. Throughout the settlement process, Hunter and his lawyers negotiated fairly and in good faith with the prosecutors. Yeah, I mean, it doesn't sound like you even had to do much negotiating at all. They just came and said, hey, we want to grant you total immunity and dismiss everything. Third, Hunter's defense says, consistent, Judge, with their terms, the government's terms, Hunter signed both agreements, was willing to waive certain rights, means he gave something up, and to accept responsibility for his past mistake. As was required as part of the plea agreement, he was prepared to plead guilty to the 2 misdemeanor tax charges in open court. And he truthfully answered your questions, Judge, including those regarding his understanding of the promises made to him by the government in exchange for pleading guilty. Hunter's understanding of the scope of immunity that was agreed to by the government was and is based on the express written terms of the diversion agreement. Okay, diversion, not plea. Hunter's understanding of the scope of immunity agreed to by the government is also corroborated by the government's contemporaneous written and oral communications during plea negotiations. So in other words, Hunter understood it this way, diversion, government understood it this way, and I've got documents to prove it. He says, and fourth, Hunter intends to abide by the terms of the diversion agreement. That was executed. That was executed at the July 26 hearing by the defendant. Hunter's already entered it, already done. He signed it, his counsel signed it, and the United States executed the agreement. And so defense says we concur, since we have an executed agreement, and we concur with the statements that the government made during the hearing. At the hearing, the government stated in open court, they said, yeah, Judge, it is a bilateral agreement between the parties, and it does stand alone from the plea deal. It's a separate contract, that it was in effect and that it was binding. And they're pointing to the transcript. The government said, Your Honor, I believe that this is a bilateral agreement between the parties and that the parties view in their best interest. He says, government, Your Honor, the diversion agreement is a contract between the parties, so it's in effect until it's either breached or a determination period. Your Honor, the position of the United States is that agreements stand alone by their own terms. And the government says the statement by counsel is obviously, as Your Honor, the judge acknowledged, a modification that we believe is binding. Okay, so the corrupt DOJ expected here is Hunter to eat it, go out there and just eat this plea deal because we are not going to prosecute you. We're just going to say this deal's binding and he's not going to have to worry about it. That's why when Hunter was out there the first time, the judge is like, would you take this if there's no immunity? He's like, no, of course not. No, I'm not going to take it. They walk him back into the closet and they say, you're going to take this deal. Okay, we are not going to prosecute you. Your daddy is in charge and we're just going to sign this document. And if there is Trump wins or some other GOP person takes over the Department of Justice, they're not going to be able to prosecute you either because we're the DOJ going to execute this diversion agreement, private contract between us and Hunter Hunty, and you can bring that back up as immunity in the future. And Hunter walked right back out there. The judge asked him the same question. Would you take this deal even if it doesn't grant you immunity? He's like, yes, I will. I'll take it. Why? Because he knew the unspoken terms were he's not going to be prosecuted. So when the judge asked them to explain themselves, as we said, the kids got caught with their hands in the cookie jar big time, both the government and the DOJ and the defense team. And the government is supposed to be prosecuting, not defending, not offering insane plea deals without precedent. So they say this all in court. The government acknowledged this in their filings, agreeing to the public disclosure. And so Hunter's defense says, therefore, Your Honor, we've got the public disclosure of the plea, we've got the disclosure of diversion, and therefore the parties have a valid and binding bilateral diversion agreement. It's already done. And the scope of the immunity was already agreed upon thanks to the diversion agreement, as we can see. And so there is just a lot of connections here. And you can just see it in, as we clean this up a little bit, they say this was executed at the plea deal in effect by all the parties. The diversion agreement details the scope of the immunity, and it is a binding diversion agreement. So Hunter is now immune. Now, this is the big FU to tell the judge to F off. And I hate to even make you think of that word, but this is the proper translation for this sentence. Hunter and his lawyer wish to thank the court for its attention to this case. That's a big F off, all right? I'm translating that from lawyer speak to English. Hunter and his lawyer wish to thank the court for its attention to this case. You're done here, Judge. Thanks. Nope, you're done. I don't even want to hear another response from you. I don't want to hear an order. You've done a terrible job. You've wrecked this case, but we're not playing with you anymore. We already have a binding agreement. It's already executed. As far as we're concerned, you're done. Don't call. Attorneys for defendant Robert Hunter Biden. And just so we're clear who these people are, Christopher Clark, Abe David Lowell, and many others. And why wouldn't they work with their daddy's DOJ to get this deal done? And so the judge, my friends, has issued an order on this. The judge is going to order the government to respond to this because something doesn't add up. They say that there wasn't a signed diversion agreement. So the judge posted this, says, it is hereby ordered that no later than noon on Tuesday, the government, you, DOJ, shall file a response. What do you say about this? Do you think that Hunter Biden is immune? Because you guys at the DOJ just appointed a special counsel. So what the heck do we need a special counsel for if Hunter Biden is immune? Because your prosecutor called Leo Weiss and David Weiss concocted this immunity deal. So it's a total scam. It's corruption through and through. We'll see what the DOJ says in response to this and what the judge does. But the White House has the reaction that you would expect. We're not going to be able to talk about this. This is very independent. I refer you over to everybody else except for me.
Can you discuss at all the president's personal reaction to, as a father, of the special counsel being appointed to continue the Hunter Biden probe?
So let me just first say, and you've heard me say this before, that this case was handled independently by the Justice Department under leadership.
That's not what whistleblower Gary Shapley says, or Joseph Ziegler says, or special agent, FBI agent, whose name is redacted, says. They all say it was highly political.
Of a Trump-appointed U.S. attorney, as you all know.
Also doesn't matter, because Trump-appointed attorney had to go to Biden-appointed D.C. attorney or Biden-appointed California attorney.
This is consistent with what the president has been saying for a long while now, going way back to his campaign days, that he would restore the Department of Justice independence from political interference from the White House. And this is want to make sure that we continue that. Since the White House hasn't been involved, just to be clear again, certainly I would refer you to any questions about this specifically to Department of Justice and certainly to Hunter Biden's personal representatives. I will say this, and you've heard this from the president, is that he loves his son and he is proud of him overcoming his addiction and how he's continuing to build his life. But I don't have anything else to add to that.
Yeah, loves his son, loves that money, loves that probably painting money too. I don't know where that money's going, but not much to say. Of course, another comment about David Weiss in particular. You know, your administration has already said David Weiss was this great guy who could do this independent investigation. You said he had all the authority to bring charges wherever he wanted. He was not a special independent counsel. He was a special counsel. You said he was independent, even though we know that he wasn't. He still reported to the DOJ. And what about David Weiss now, who already botched the first investigation, being appointed and given more powers that you said he already had? Can you please answer this, please?
Now that this investigation is in the hands of a special counsel, which judge does have some more sweeping authority. Just to be clear, can you say with certainty that David Weiss isn't going to unearth any connections between the president and his son's business dealings?
I'm going to continue saying what I have said before. The president was not in business with his son. That still stands.
That changed, though. It used to be he did not talk to his son about business. Now he's not in business.
And just don't have anything else to add. I've been very clear about that. The president's been very clear about that. Anything else specific to this case, I would have to refer you to the Department of Justice.
So we're going to hear that a lot. It's going to be like a broken record. Now, we do have some reaction from James Comer over on the Oversight Committee. He says, I never wanted a special counsel at all. This is done to stop and stall our investigations, which would have been actually legitimate because it would have been adversarial. Now we've got David Weiss, who already failed the first time, already botched the first 5 years, going to get more power.
Well, this is a joke. All that Merrick Garland did was validate the point that many Republicans have been making, that the Department of Justice was weaponized. Look, I've been very vocal in saying we didn't need a special counsel. I've been on the other side of a lot of my colleagues in the House. The one reason I would give for not wanting a special counsel was what we've seen. The fact that I have no confidence that Merrick Garland would appoint anyone credible. I never dreamed he would do as bad as he did with Weiss. Not only did Weiss drag his feet for 5 years and try to negotiate a sweetheart plea deal with the president's son, he also let the statute of limitations run out. That was one of the biggest complaints from the IRS whistleblowers when they testified before the Oversight Committee, was their frustration that they knew they were coming up on a hard stop as far as trying to prosecute the president's son for obvious crimes of tax evasion and violation of the Foreign Agents Registration Act. But Weiss intentionally let the statute of limitations run out. We also learned in that testimony, Trey, that the IRS whistleblowers never knew about the 1023 form from the FBI that Bill Barr handed over to Weiss that alleged both Hunter Biden and Joe Biden were involved in a bribery scheme in Ukraine, even though Weiss knew the IRS was investigating suspicious wire from Ukraine. So we have no confidence in Weiss. We have no confidence in Merrick Garland. This will not deter our investigation. We're going to continue to move forward and try to present the American people with the truth about this family.
All right, so that's Comer reacting. They know that this whole thing is a cover-up, and we're going to see if the judge does anything about this. I tend to think that she's going to. I'm not sure that she's going to be very happy with that reaction. Judge Norika being told to F off by the defense. We're going to see how that lands as we continue to cover. Of course we will. Thank you for subscribing, my friends, and liking this wherever it is you're watching this. There's a lot more to go.